Hey, welcome once again to Lehto's Law. I'm Steve Lehto, attorney at law in the state of Michigan. I've been practicing law for 28 years in the fields of consumer protection and lemon law. And the reason I'm doing the long intro to my show is I've got a guest with me today, and it's Leonard French. Leonard, how are you today, sir?
I'm good, Steve. How are you?
I'm doing very well. You and I did a joint discussion, collaboration last week, which went very, very well. And in fact, I got a ton of feedback, both from people who were already subscribers of mine, but were secretly seeing you behind my back. And then also from people who saw me on your channel, had no idea who I was, came over and watched me and said, hey, I saw you on Leonard's channel.
Yep.
So you have a channel called Lawful Masses.
I do.
And you've been practicing law in Pennsylvania. And one of the cool things is, besides the fact that you're just another YouTube lawyer like me, and you got a ton of cool stuff behind you, by the way. And you know, it's funny because all of my stuff tells a story. I'm not sure what the story is. It's some kind of schizophrenic, confused, nonsense that you might get from a homeless person if you woke them up in the middle of the night. But you've got quite a bit of stuff behind you as well. So we must be kindred spirits of some sort.
Yeah, I think we're cut from the same mold, or a brother from another mother, I think I said one time.
There you go. And also, I'm wearing my I do not consent shirt. Because I know that...
I'm wearing my Pennsylvania School of Bird Law shirt.
There you go.
From Always Sunny in Philadelphia.
You're the first person I've ever had on my show who did one of these with a shirt, but that's another story altogether. But it's kind of funny because I first became aware of you when I got on YouTube and started poking around, and I'm fascinated by the sovereign citizens. And we're not going to spend a lot of time on sovereign citizens today, but I have to mention them because just yesterday, I've done videos debunking particular pillars of their arguments, such as, you know, why that UCC 1308 signing with reservation thing is nonsense, or the Supreme Court said you don't need a driver's license, nonsense. And somebody sent me this long cut and paste thing yesterday that said, there's not a single state in America that requires a driver's license to operate a motor vehicle on the roadway. And I said, except that all 50 of them do.
Yeah.
And the person responded to me by saying, I want you to cite me the law in all 50 states. And I said,
"Are you paying
no,
me?
I haven't got that kind of time." And the guy goes,
$50 an hour. Go ahead. I'll do it.
And the guy goes, well, here's your opportunity to change my mind. And I go, I don't want to change your mind. I don't care what you think. Why would I, what kind of work is that to go through and dig up the 4 different statutes in 50 different states? So you must encounter that all the time also, because you occasionally dabble in this area, right?
Oh, yeah. I definitely get told how copyright law works, or just how the law works in general, or definitely lots of comments on how stupid it is, or why it shouldn't be that way, or a conclusion that isn't really based on anything, that when you look any further, that conclusion doesn't hold up. But my favorites are the people who speak without any basis whatsoever, just something must be true because I said so, and then we can stop there because I made half an argument someplace. As lawyers we have to look things up.
But you've occasionally dabbled in the sovereign citizen field, though, too, haven't you?
I have not represented sovereign citizens. I just cover them on my channel.
No. I'm talking about on your channel, making fun of them. I mean, discussing
Edward
them.
Thomas Kennedy, Amro El Ansari, and there's a couple others that have hit the channel page a couple times, and they're very popular. They're some of our most popular videos, especially when the sovereign citizen fails. I think one of our most popular videos was a Florida sovereign citizen who was trying to make a fake arrest warrants for judges through some kind of fake arbitration court, which on one hand sounds like, you could have a private arbitration system, but it has to follow some rules, and it doesn't issue arrest warrants for judges. And so now he's in jail for like 30 years and literally sent a please send help message, not to me or anything, not like a attorney-client thing, but more like has sent letters and filed something with the court that basically said send help.
Right. I don't know why. I could watch the videos of those guys getting their windows broken out at the roadside all day long. To me, those are like just...
you can beat the ride, you can't beat the time.
Yeah, you're not doing something right if you're at the side of the road getting your window broken out and you're yelling, I do not consent. I do not consent. So,
am I free to
hence,
go? Am I being detained?
Hence the shirt. Yes,
and
you
then
are.
there was R. Kelly had one. He received a court pleading or something served on him, and he wrote back in an answer, I do not consent to these pleadings or something, and I do not accept this offer to contract. It's like, no, court pleadings are not contracts. We could definitely talk about the social contract, but that's not a contract. That's we're all here not by choice. Like, nobody asked me if I wanted to be born, and they can't. It doesn't work that way. So we don't have a written contract of how I'm going to agree to live in society. We have to all more or less figure it out. Welcome to humanity.
Right. Yeah. Okay. So my field of law, I specialize in lemon law, which is defective automobiles. And because of that, I'm basically, restricted to the state of Michigan because that's where I'm licensed to practice law. And I know that you practice law in Pennsylvania, but you practice law specifically. What's the field in which you practice?
Well, I more or less practice nationally wherever I'm within the rules of professional conduct, using local counsel or whatever, because my cases are kind of like reverse multi-district litigation, but instead of one defendant being sued by a million plaintiffs, it's a million plaintiffs being sued by one defendant throughout the country. So I'm very good at defending people and settling cases and negotiating and working through the copyright problems involved with Strike 3 Holdings and Malibu Media cases, who are two quote-unquote copyright trolls, my opinion, and two judges' decisions, but, don't want to defame anybody. But they are copyright plaintiffs that file mass litigation. They use what I would consider underhanded or barely ethical tactics, like filing a copyright discovery action in Florida state court in Miami-Dade County to try and get identities of defendants in a way that makes it difficult for the defendants to defend themselves. And it also seems to be that now they're using that as triage to figure out who to really go after and who to just get simple settlements from. So, that's very complicated from how do you get from state to state, and how do you, what are the copyright issues involved with BitTorrent file sharing, like basically the Pirate Bay. People go on the Pirate Bay, download the plaintiff's material, and then get sued for it. And I have to figure out... Okay, and I was going to
ask you, so my lawsuits, my cases, my clients generally start with someone calls my office and goes, I've got a defective car.
Yeah.
What is the phone call that you get that starts one of your cases? What's the prototypical phone call or the request for help that you hear?
If someone receives a notice from their internet service provider that says that they're being sued or their identity is being sought by subpoena, they call me. And I that's basically the way every case starts, because they're all John Doe cases. I literally have alerts out on John Doe copyright cases and get alerts every day when a new case is filed. And the John Doe nature of it means that they can't serve the defendant, so they have to ask for the defendant's identity first.
Right.
You can't send a subpoena in federal court until you have either a court order, which is not normal, or federally licensed or federally admitted attorneys can send subpoenas for anything as long as they're in the discovery portion of their case and they're sending subpoenas for that case. So I don't need to seek court approval to send a subpoena, but I do need to seek court approval when I have to go through the internet service provider because of various privacy laws, especially the Cable TV Privacy Act of 1984.
Okay, so someone is, I'm just a guy. I've got an internet connection. I'm at home today. What do I do that gets me in trouble? I've downloaded something off of some website. What have I downloaded? What?
Very specific.
Break it down for me.
It's very, very specific. So you have to you have to meet certain conditions. One, you have to be using your internet connection like everyone does normally without any further protection. No VPN, nothing hiding your IP address. You're just going out and surfing websites. You have to go to very specific websites. I'm not going to advertise for them. Everyone knows who the Pirate Bay is, and that's the only one I'm going to name. But there are many websites that host torrent files, TORRENT, literally .torrent files.
Okay.
Sometimes there's a magnet link or something, which is another weird kind of link. It's just a text link that gets you in if you have the right program. So you have to go to a website, you have to find a file you want to download, you have to get the basic torrent file link, and you have to already have the right software program installed on your computer. The BitTorrent is a protocol. It's a perfectly legal protocol, and it's very legitimate. It distributes things across the internet through peer-to-peer file sharing. Lots of legitimate companies use it in very legitimate ways. For instance, I think World of Tanks from Wargaming uses it to distribute their large number of files for the World of Tanks game, and uses peer-to-peer to help keep their own distribution costs down. But then Bram Cohen in 1996 or so, or 97 or something, invented this in a way that in order for you to download via this particular peer-to-peer protocol, you also have to be sharing what you're downloading. So as I'm downloading, I get the first piece of the file, and then I notify the rest of my peers involuntarily through the protocol that I have a piece of the file and it's now available for others, and others will contact me and say, hey, I need that piece of the file, and you're the closest peer, give me that piece. And as I'm downloading...
Let me guess here. So you've basically done two things wrong. One is that you are downloading something that's copyrighted that you've got no right to download.
Correct.
But you're also sharing it. Now you become part of the problem of who's sharing the copyrighted material without the rights to share it.
And that sharing action tells everyone what your public-facing IP address is. So they can't see all the way to your computer, but they can see to your router, to your Wi-Fi router, that where your internet connection comes in. Basically, your modem, your cable modem, your DSL modem, that has a public-facing IP address that you can go on to whatismyip.com or whatever and see what that is.
Right.
If they get that IP address, they can trace that back. Very much like a phone number, they can trace it back to a provider in a region, and then that's all that they need. They can then subpoena that provider. They provide a minimal amount of information. Literally one hit is all that it takes for them to sue and get an identity. And then from there, they, let the chips fall where they may in a copyright action in federal court. Many times they don't want to go to litigation either. It's very much like a shakedown, but they have to appear very tough. Otherwise, people like me would call their bluff all the time. So the chips fall somewhere in the middle. It's really funny, because you'd think that this kind of mass litigation, every case would be exactly the same, and up to a point they are. As soon as you get into the litigation, though, it's now how are they going to prove it? What are your circumstances? Who do you live with? And then we also get into weird questions of like, how much are you worth? Are you a giant target for them, or are you a nobody as far as wealth is concerned? I don't mean that people who aren't wealthy are nobodies. I just mean nobody to them. And so
they're simply looking for. They want money. They don't want an apology. They don't want you to feel bad. They simply want money.
Oh yeah, we've offered apologies. We've offered everything except money, and they've said no.
Yeah, we can't spend that. Here's the question: what's the most common thing that people have done that got them in trouble? Downloading music, downloading movies, downloading games. What are they downloading?
Adult entertainment.
So probably movies of some sort. Because I remember there was a big case out of Minnesota, wasn't there, involving some attorneys who were filing all kinds of... Yeah, okay. Yeah.
So Prenda Law was John Steele and Paul Hansmeier and Paul Duffy, who is now deceased. John Steele and Paul Hansmeier are now in jail for 15 years for Paul and 5 years for John. John cooperated. And what they did was all of everything I just said, except they didn't own the underlying copyrights. They started making them up. They had a guy named Alan Cooper sign one piece of paper, but he was really signing a different one, and it was a false copyright assignment. And then eventually, I think it was I don't want to get the name wrong, but there was a California attorney who hauled them into court, got Judge Otis Wright's attention, the same one who lambasted Christopher Hook, and is going to be coming after his law license. Judge Otis Wright then and his clerks wrote a opinion that was all based on Star Trek references. This court is on red alert, that kind of thing. It's a really good one. I recently did a video on that because it was epic. And so, they eventually got the Minnesota Attorney General after them and the FBI, and they're in jail. Yeah,
and of course, underlying all of this is, if I'm being sued because I downloaded a Taylor Swift song, I'd be embarrassed, but not humiliated.
Yeah.
Maybe. But if I'm being sued because I downloaded some wacky adult video, I might be a little more mortified if that became public. And so underlying many of these is this thing that we're going to sue you, or we are suing you, and it's going to become public unless you quickly solve this problem by paying us money. Is that part of the hammer they have here?
And getting protective orders and confidentiality agreements. Those are basically our bread and butter right now, because we have, for one reason or another, whether it's I'm not, I don't come across as the world's, best litigator or something, I don't know. But a number of people simply don't have any fortitude or stomach or resources to fight their case in court. So it becomes a cost control thing. And I'm often recommending to clients that, well, if you can't go through a full defense with expert witnesses and analysis of your hard drive and depositions and everything, then the best we can do is get a protective order and talk to the opposing side, get a confidentiality agreement, talk about the circumstances of the case privately, and get the case dismissed after a settlement, which is also not helping the cause, our larger cause of getting rid of these kinds of copyright trolls. But I don't have a fiduciary duty to the cause. I have a fiduciary duty to my client. So I have to do what's in the best interests of every one individual client. And I have tried to convince clients to fight for the cause, but I also have to be careful, because if they fight for the cause because I told them to, and we lose a large amount of money or something, now they're going to turn on me and go, hey, you told me to do this. So we have a rather maybe an hour or two hour long conversation just about the risks of going into litigation.
Right. And that's one of the things that people don't understand. If you think about any high-profile case that you can think of, like, Roe versus Wade, for that case to get there took somebody, whatever your position is on the case, it doesn't matter. For that case to get to the U.S. Supreme Court meant that someone had to actually step up and go, I'm going to take this case up on principle.
Yeah.
And so whether someone's going to take a copyright infringement case up on principle at the risk of their family finding out what they watch in their private hours is a whole different thing. And here's a question, and I like to tell people horror stories just so you understand where the parameters of a discussion are. If somebody legitimately did violate the law, downloaded some stuff that was legitimately copyrighted, and then peer-to-peer shared it inappropriately, likewise copyrighted properly, and the proper copyright holder came after them, what are the remedies, or what are the bad things that could happen to you under federal law?
Well, they go after these people for direct infringement only. They used to file for contributory infringement, and then they realized that statutory damages under copyright direct infringement are more than enough. Nobody can afford to pay for the statutory damages alone. So why go after them for contributory infringement and have to prove a whole other set of facts in your trial?
Okay. So how much money are we talking here? Give me dollars.
We had this case. So Michael Bailson in Philadelphia, Eastern District of Pennsylvania, held a trial. By the time we got there, it wasn't much of a trial, because all 5 defendants were more or less, in fact, liable, and it was just a matter of establishing it. And he said that he would find them liable under the minimum statutory damages, $750, but it was willful copyright infringement, so he multiplied by 3, a trebling of damages, which is normal for that kind of thing. So $2,250 per title, and most of these companies don't sue for anything less than 4 titles in Malo Media's case, or about 20-some titles in Strike 3 Holdings' case. So Malo Media's got you on the hook for $10,000 right off the bat if you're liable, and Strike 3 Holdings has got you liable for about $50,000. And that's really scary, and that's not even the maximum damages. We did have a guy, not my client, but a man named Brian White, Bryan. He's not confidential. He revealed his own name. He erased his hard drive. He reactivated Windows. He turned it over to the opposing counsel's forensic expert in an encrypting USB enclosure. It screwed everybody up for months trying to figure out what's going on, and the judge smelled it too. So the judge appointed his own independent expert, and it turned out that all that stuff was true. He had erased the hard drive and all that. And the judge hit him with everyone's attorney's fees on the opposing side, and the expert witness fees, and multiplied his $2,250 damages by 10. He had only downloaded 5 titles, but was found liable for $241,000.
And that's inclusive of attorney fees?
That was all the attorney's fees inclusive. It was $125,000 or so, or a little bit less than that
So
for the 5.
Order over $250,000 damage award against that guy for 5 titles?
For 5
basically?
titles, for lying under oath, maintaining the lie, falsifying evidence, and he was referred to the U.S. attorney for perjury charges, which I don't think he ever actually received, but...
Like we say, mistakes were made.
and he named his newly erased hard drive Squeaky, as in squeaky clean.
Oh boy. So that's the thing. So, it's funny because, when I talk to people about, everyone jokes about, like, tearing the mattress tag off your mattress or something, and people think that, well, this, you watch the thing at the beginning of a movie and it goes, piracy is a not a victimless crime. You will, blah, blah, and you see these penalties go by, and after a while, people forget this stuff.
Oh yeah.
And the crazy thing is but there are people out there. I remember back in the days of Napster. Back when I remember hearing about people in Michigan getting sued for downloading songs under Napster,
Yeah.
And the only reason anybody was safe back then was simply herd mentality, and that is someone in the herd might get hit. It probably won't be you.
Yeah.
But that's not a real good way to live your life. It's kind of like driving down the road going, well, hey, everyone's speeding. I won't get a ticket.
Yeah.
Someday you will. And then it gets ugly.
Yeah, that's very true. I hear a lot from my clients things like, "Oh, but my Wi-Fi is." Just tell them my Wi-Fi was open. Just tell them that I didn't have anybody logging. Like everyone could just log into my network, and so I live in an apartment building. Just tell them my Wi-Fi was open. I'm like, okay, I'll tell them that, but when they come back and say no, the next step is they're going to get you under oath, and I'm going to counsel you not to lie under oath because see Brian White and the $241,000 copyright judgment.
Wow. So how long have you been doing this kind of law?
About 8 years now. I've been actively practicing since October of 2011, but of course it takes a little while to get started there. My first of these kinds of copyright cases were in the spring of 2012, so around 8 years we're getting up to.
Okay.
About 1,000 clients.
Okay, and so here's the question: Did you kind of fall into this, or does this area of law fascinate you, or how did you get into this? Because I mean, there aren't until you came along. I didn't know anybody specialized in this. How did you
one
get
of
into
a
this?
handful. There's only a handful of us in the country that are very experienced at this. Me, Cynthia Conlon in Florida, J. Curtis Edmondson in Seattle, Jeff Antonelli in Chicago, and a handful of others that I mean, I might have forgotten somebody, but those are the really big ones that I know about.
Okay.
And I mean, me myself, I've handled somewhere around 5 to 7% of these cases in the past 8 years in the entire country.
Wow.
And entered my appearance in various federal courts around the country, sometimes pro hoc vice, sometimes as admissions. And the next one we're doing is SDNY. I'm working on my SDNY admission, which I technically don't meet the requirements, so I might have to challenge some of those requirements because they have some odd requirements like you must be a member of the State Bar of New York or Vermont, but nobody else. And you must know some attorney there to sponsor you for a year. So I'm going to find out whether or not they're actually enforcing those requirements. I've heard that they're not, so we'll see.
Yeah. And by the way, for those of you who are not attorneys, it's the Southern District of New York. Each state has federal courts that overlap where the states are. Michigan's got the Eastern District and the Western District, and so on. I'm a member of the State Bar of Michigan, and I'm admitted to practice here in state courts and also in both of the districts of federal court. But I don't spend much time in federal court because federal rules of civil procedure give me a headache.
Oh, see, it's the exact opposite. I love it. I can practice remotely for the most part. The judges are usually very easy to work with. As long as you're behaving yourself, they usually don't really care too much. As long as you're not causing problems.
But see, I get that though, because obviously, if you're a guy who understands computers and the field of law you are in, I assume you have a slightly higher understanding of computers and networking and so on than the average guy like me who just plays on the internet and makes videos. And so everybody I've known who enjoys federal court are also the people who like rules and enjoy understanding nuances of rules.
Yeah.
Let me take a guess. Do you play chess?
I do not play chess.
You're kidding me.
I do not.
There goes.
I play lots of video games. I love lots of. I like action video games. I played World of Tanks for like 3 years. I'm currently into Rocket League. But I like artistic and unique video games. So Death Stranding, a weird game about reconnecting America by carrying the mail is a really weird game, but it's also really good. And I like it because it's so unique.
Wow.
There's no other game out there like it. So I just have to try it and play it and see what Hideo Kojima has come up with.
Well, that's funny. Well, I literally just settled a case in federal court, the Western District of Michigan. Very, very strange case, but it had to be filed there for technical reasons. And I actually brought aboard a guy who's a rules guru. And it was just fun. I'd have these conversations, and it was almost like he was bilingual. Like he could actually say to me, like, "Okay, Steve, don't worry, I'll take care of that. You wouldn't understand." And it was just procedural stuff. It's just procedural stuff. But this is, not that interesting to people who aren't attorneys, so I won't go there. But so these kinds of cases, are you seeing more of them, less of them? Do you think they're going to continue going up, or is it going to start going away? Or what do you think that the landscape looks for the future of these kinds of cases?
Well, it sort of looked like they were going to start going away, and I started making plans to diversify, and I have diversified. The YouTube channel's part of that, and I have further plans to diversify because these cases are volatile. Malibu Media sued so many people so fast, it actually did have a deterrent effect, and now they have fewer cases that they file, and they only file for 4 or so infringements. Strike 3 Holdings has only been doing it a little while, is also coming at it very quickly, 3,000, 4,000 lawsuits in 3 years that they've been filing. And now they stopped filing in August, and I started changing everything around so I could do something different. And it then turned out that what they were planning to do, and what they eventually did do, was file a dozen or more cases in Florida, Miami-Dade County Court as a pure bill of discovery case. So before, not a complaint, but rather just a request for a subpoena, but based on copyright, BitTorrent infringement on the internet, doesn't sound like something that Florida has jurisdiction over. But ISPs aren't going to go to bat, or at least they haven't gone to bat. They did all the way back in 2012, but they didn't win, and so ISPs don't really oppose these subpoenas directly anymore. So what happens is, if we get a call from a client who doesn't like that they're being subpoenaed in Florida, if they meet certain conditions, like they're not in Florida, we can definitely get the case thrown out, or at least address that issue, and likely get the case thrown out. So far, the opposing side has even agreed to throw the cases out, and then they turn around and immediately file in federal court. So either they get a bunch of easy identities from Miami-Dade County, or they go straight to directly filing a lawsuit very quickly. It was only a week or two after we won the thing in Florida, or rather they dismissed voluntarily. And then they turn around, file a federal suit, and then we have to figure out everything from there. And a totally different strategy in federal court than it is in state court as far as settling the case as well. So all of these nuances have to be addressed, and that's where I come into it as far as my value as a representative. I like to call myself a harbor master. If you're familiar with the term, the harbor master is the guy who gets on a tugboat and drives all the way out to the big cargo ship before it gets to port, gets on while the thing is still 25 miles out. And I guess even some harbor masters might even fly out on a helicopter if it's really important. But the harbor master knows all the rules, and knows the channel, and knows the dangers, and knows the weather, and can drive that ship to port safely with the least damage possible, which is what you want. So that's what I do, is I guide my clients through. We of course do the work full service, but we act as a guide through what's going on, because it's a shakedown. It's a very much a mafia style, or a organized crime style shakedown. They come in looking for their protection money. What do you need protection from? Them. You need protection from their aggressive lawsuit, which does have basis in law, so it's not extortion. It's not an illegal extortion scheme. It just really feels like one. So I call it a shakedown.
Yeah. And the interesting thing is, and I tell people this all the time, I say, look, I spend time in court all the time. You spend time in the court all the time. The average person's never been sued before. So when they get sued, it's all a new experience. So half of what attorneys do is simply explain to people what's happening and act as a guide, which is the parallel I always use, but I like your harbor master one as well. But the thing is that people who have seen me interview other attorneys before, I often get this criticism, but it has to be asked. And that is that if someone gets sued, they've been served with a lawsuit, and the lawsuit says right on it, you're being sued, you've got 21 or 28 days to respond, or depending on the rules of the court you're in. And it'll say you must answer this complaint or bad things will happen to you.
Yeah.
And I've heard of people who get sued and they go, I can't afford an attorney, so they don't do anything.
Yeah.
Or they get scared, they don't do anything. And I try to explain to people, I'm not just saying this because I'm a shill for the legal profession.
Yeah.
You need to call an attorney, at least make the phone call. And then if you decide not to hire one, that's fine.
Yeah.
But you should call an attorney just to find out, because sometimes it's not as bad as you think. Don't imagine the worst. I mean, the worst could happen, but let's not be pessimists right off the bat.
Right.
So somebody, I'm assuming, hopefully most people call you right away, but I do you occasionally get the phone call saying, hey, I got this thing and I ignored it, now bad things have happened to me?
Well, the first thing that happens is a subpoena, and then if they don't respond to any demands or anything that come after the subpoena, and some courts protect the defendants too. They say that opposing counsel can't contact the defendant directly, even with a settlement demand. They then have to go to service. So they have to name a defendant, they have to get a summons, they have to serve it on them, and then sometimes the client is contacting us when that has happened. And once in a while, it's either after that, maybe they've already been defaulted or something, and even then we can still talk about settling the case or figuring out how to undo the default, but much more expensive as we get closer and closer and further into court.
Yeah. And it's harder because imagine the default is you've been pushed into the hole. Now you got to climb out of the hole first just to fight.
Yeah, you need you need good cause to take out a default as well.
Yeah. And so, I always explain to people that when you get defaulted in court, the other side doesn't come into court and they're not conservative and say, well, we only want a little bit.
No,
when they get a default against you, they will ask for everything they can get, and the judge might look at them and go, well, the other side's not here. You can have everything you want.
Yep.
And at that point, trying to undo that later is a nightmare.
Fortunately, and this is kind of funny how this works out, but let me be clear here, this is not legal advice to anyone listening. Sometimes a judge will see the default, see the sort of unfair positions of the parties, the leverage that the plaintiff has and the position that the defendant is in, and they will say, well, okay, I've got to find you in default, but I don't have to give you $150,000 in maximum damages. I'm going to give you minimum damages, not even a trebling of damages, so $750 per title, because there was no defendant to prove willful copyright infringement. They could only prove the underlying copyright infringement by default, but they couldn't prove the willfulness or the intent factor without more. So once in a while, I've heard of a defendant being able to get a lower judgment by not showing up, but that's not something you can count on, and it's definitely something you would want to do with your attorney.
Well, and I can also picture a case, and I might be wrong, but couldn't a plaintiff in a situation like this say, Your Honor, we want to put in proofs to get us a larger amount, or no?
Yeah, they could try, but if the defendant is uncooperative and they can't get a deposition or something, that's often unconvincing and unavailing to the judge. Okay. It doesn't happen often, because I know that under Michigan state law, court rules, if you file a complaint against somebody with a specific dollar value in it, you can get a default judgment for that amount. But if you pled, anything over $25,000, you've got to put in proofs to get a judgment amount. So I was thinking maybe that might come into play or something. Yeah, it does. I don't know that they call it that, but yeah, there will be an evidentiary part of a default judgment here.
Okay.
Yes.
Okay, so here's the thing. We're getting short on time here because my videos are shorter than yours. Plus, I'm just getting over a cold, I'm running out of steam.
I love this stuff. I can keep talking about this for hours.
I know, so can I. So here's the deal. When I talk to people, and they people say, Steve, sum up what you would tell people who are buying a brand new car or a used car. I got boom, 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 boom. I got the advice. I've done whole videos. For somebody who is on the internet. And they're talking to you because you're a lawyer, not just an internet lawyer, but you're also a lawyer who deals with the internet.
Yeah.
Okay. What's your advice to people about the internet that you'd give them as an attorney in your specialty?
Well, with this kind of litigation now happening, there's kind of a new normal for owning an internet connection. If you host an internet connection, you have to be aware that you might be the one who gets subpoenaed if anybody who uses that internet connection does something illegal. Especially things that are truly criminally illegal, downloading certain kinds of material that's not supposed to be downloaded or seen.
Right.
That I can't really want to mention on YouTube.
Right.
But Also, if you yourself or one of your family members or just anybody else who gets onto your internet connection goes and downloads adult entertainment or other files, music and movies and games and stuff do get sued over, but it's a totally different thing, and they ask for a totally different amount of money, and it's usually more of a bluff in many cases. But basically, you must talk to the people who use your internet connection and make sure they're not doing those sorts of things. I've given advice out over the years, like use a VPN to hide your public-facing IP address. Now, of course, that slows down your internet connection, and some banks and things won't even let you access their website if they detect that you're using a VPN. So, and it's also not legal advice. At some point, someone's going to figure out how to detect who you are through your VPN or whatever. So you can't count on that, but at least that's a step. And I've even told people to invest in like a layer 3 network switch, which is a very expensive piece of equipment, but it has what's called stateful packet inspection, and you might be able to block BitTorrent activity in general and make sure that it doesn't happen on your network. That's maybe a bit extreme.
Yeah, and one other thing, and this is one of the things I often tell people, is I have people say, but Steve, I would never do that, and no one I know would ever do that. But, for instance, let's suppose that you're a parent and you send your child off to college.
Yeah.
And your child in college is sharing space with people they just met. These are fellow college students of theirs who would never do anything wrong.
Yeah, and never be so poor that they would want to download things for free.
Yes. And so you suddenly have 5 people in a house all using the same router. Heaven forbid what someone else is downloading, but again, they're going to be so close to it, they could be collateral damage on that one.
I've literally seen that in that scenario, and then an extension of it is when your child comes home from college and still has that software running on their laptop, now connects to your Wi-Fi network and accidentally, not even on purpose, but accidentally has that software running in the background and sharing, and might not even realize it. And now you're being held liable for it. And if that child is over 18, you don't have the benefit of any parental liability on the part of a minor laws that limit liability to $1,000. Or New Jersey, for example, is like no liability unless they've damaged public property. So it becomes a tremendous liability. So the advice that I would give would be make sure you know what's going on your network on some level. Make sure that you're fully okay with signing an affidavit saying I didn't do anything wrong, and you're getting before a judge. I mean, we were starting to talk to companies. I'm starting to hear about insurance for these kinds of things. You might be able to get an umbrella policy for your homeowners or something that covers something that happens on your internet connection. So far, we haven't had any clients who successfully made a claim on their homeowner's insurance, but you would want to talk to them about that, as that is becoming a thing that happens now.
Okay. Well, very cool. Leonard, I think that's about a half an hour or so, give or take. Again, my head's foggy from the cold, and we'll call it a metric half hour. How's that?
Okay.
So I appreciate it, you coming on my show. I came on yours. I'll put a link below to your YouTube channel.
Yeah.
And also, you have a website for your law practice, correct?
Yeah, so I'm at either leonardjfrench.com, LeonardJFrench.com is my website. It's very basic. I really need to update it. We keep the torrent stuff separate on a website called torrentdefense.com.
Okay.
And we have lawfulmasses.com for the YouTube channel.
Okay, I'll put all those links below, and I'll just let you know right now, my website's lehtoslaw.com. I've had that website for years, and it looks like it. And I have guys, and I'm sure you do too, who go, Steve, your website looks a little old and creaky. And I'm like, you know something?
Yeah.
People can find me. That's all I care about.
As charged. I said the same thing when I started practicing law. Like, all I've got to do is have a better website than these other attorneys. And it does. To a point, you just need to have a better website than some other attorneys. But now I'm one of the attorneys who has a dinosaur of a website run by WordPress.
And then I realized that actually what it is you just need your website to come up higher in the searches.
Yeah.
And that's the key. So, anyways, Leonard, thank you very much, and we will talk again soon, I hope.
Yes, definitely. I would love to do this way more. Once a week or twice a week would be great too.
There you go. Questions or comments, put them below. I'll talk to you guys later. Bye-bye.